Your Honor, recording.
All right, good afternoon, everyone. The Appellate Court for the State of Connecticut is back in session. We will now hear the matter of ZACHS versus Commissioner, docket number AC 43380. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Alexander and Judge Bishop. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances, let me remind everyone that this argument is being live streamed on the Judicial Branch's YouTube channel. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, counsel are reminded not to disclose such information during arguments. I would now ask that everyone participating in this hearing identify themselves, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall.
Good afternoon, Judge Alexander.
And I'm Judge Bishop.
Good afternoon, Jennifer Smith, and present with me off camera is co-counsel Attorney Romano.
I'm Samantha Oden on behalf of the Commissioner of Corrections.
All right. Thank you, counsel. Prior to this hearing, you should have received procedural instructions. Do you have any questions with regard to those instructions?
No, Your Honor.
Your Honor.
Right, a few additional preliminaries. When you are not speaking, if you would please silence your microphone, but leave your video on. We want to ensure that we do not lose anyone, and the record will reflect that Judge Bishop is participating by audio, and because of some technical difficulties, his video is not on, but we do have him by audio. Also, let me state the obvious. When you are not speaking, please try to comport yourself as though you are we were in the physical courtroom, so as not to create any distractions for the judges or opposing counsel. Each side will be permitted 20 minutes of argument. I will endeavor to give you a 2-minute and 1-minute warning. The appellant may reserve a portion of that time for rebuttal. Just let me know if you wish to do so. And counsel, are you ready to proceed?
Yes.
All right, you may do so.
Good afternoon, Your Honors. I'd like to initially request 5 minutes for rebuttal, please.
All right, that's fine. Go ahead.
Thank you. This case deals with an attorney presenting two antagonistic defenses, one that fits the facts and one that didn't. Attorney Daly presented the mental defect defense in conflict with the inadvertent discharge defense, which was the only viable defense in this case. While there are certain cases where inconsistent defenses can be effectively argued, this was not one of them. As the petitioner's expert, Attorney Carlo, testified, Attorney
Smith, forgive me for interrupting you, and I'll suspend your time here. Judge Bishop, for some reason, when your video came on, we started hearing feedback, some significant feedback, at least I am. So I think perhaps it would be best, and I hate to ask you this, to cut your video.
Well, no, I think his, Judge Bishop, is your cell phone really close to the speaker? Maybe it's pulling in the speaker.
All right, so let's confirm now that Judge Bishop has audio in this fashion. So if you want to unmute yourself and just let me know. No. The audio isn't working on the in Judge Bishop's Teams. All right, Judge Bishop, I can see that you're talking, but we can't hear you. So I think we need to go back to our original plan.
If he wants to stay on video, Judge Mall, I can call his cell phone from my chambers and put it on speaker, if that works.
All right, do you want to try that?
Sure.
Okay, let's see if that works.
Yeah, the key is not having the speaker close to the microphone.
Yeah.
He is on speaker now.
All right, so Judge Bishop, can you say something so we can make sure that we can hear you?
I can hear him and he can hear us. So if he has a question, then I'll take it off of speaker and just ask the question that he needs asked.
All right, is everyone comfortable proceeding in that fashion?
Yes.
Yes, Your Honor.
Okay, so both counsel have indicated that we can proceed in that fashion. So let's do that. All right, so Attorney Smith, I apologize for the interruption. Why don't you just start from the top? You'll have your full 5 minutes for rebuttal. I'll give you 15 minutes now.
Thank you, Your Honor.
Thank you.
This case deals with an attorney presenting two antagonistic defenses, one that fit the facts and one that didn't. Here, Attorney Daly presented the mental defect defense in conflict with the inadvertent discharge defense, which was the only viable defense in this case. There are certain cases where inconsistent defenses can be effectively argued, but this was not one of them under the nuanced facts of this case. As the petitioner's expert, Attorney Carlo, testified, Attorney Daly's presentation of the mental defect defense was objectively unreasonable for three reasons. First, there was an inadequate factual basis for the mental defect disease. It wasn't supported by Mr. ZACHS' own testimony, and none of the other defense's other witnesses, including the defense's own expert, Dr. Opsel. Further, the mental defect disease was severely undermined by the state's two experts, so much so that Attorney Weiss advised Attorney Daly not to present it. Second, the mental defect disease completely undermined the petitioner's testimony about the inadvertent discharge defense. We have the petitioner testifying that the gun inadvertently discharged after the victim knocked it out of his hands and he caught it. Yet, counsel's simultaneous presentation of the mental defect defense undermined the petitioner's testimony because it required counsel to concede that the petitioner volitionally killed the victim, albeit due to mental disease or defect. Third, in response to the mental disease or defect defense, the state was allowed to present a rebuttal case involving the petitioner's prior bad acts of displaying a firearm. The rebuttal case damaged the defense because it undermined the credibility of all the witnesses for the mental defect defense and the petitioner's testimony. This is simply not a case where factually inconsistent defenses can coexist. When raising an inadvertent discharge defense, counsel's asserting that the defendant did not intend to kill the victim, whereas when raising a mental defect defense, counsel must concede that the defendant volitionally killed the victim due to a mental disease or defect. Attorney Daly's arguing that these two positions, Attorney Daly's arguing of these two inconsistent positions was not reasonably strategic because the defenses conflicted so severely that a jury would be inclined to be skeptical and ultimately discredit both of them once the mental disease defense was presented. Attorney Daly, the record reflects, did not understand how the affirmative defenses worked and did not understand how devastating the mental disease or defect defense undermined the inadvertent discharge defense. The record further shows that Attorney Daly had a fundamental ignorance of how to present the mental defense, the mental defect defense, based on his ignorance of who even bore the burden of proof. He mistakenly believed that the state bore the burden of proof, when in fact, it was the defense who bore the burden of proof. Contrary to the state's assertion, Attorney Daly knew or had reason to know that the presentation of the mental defect defense would result in the admission of the harmful prior bad acts evidence. Attorney Daly knew that the state wanted to present these witnesses well in advance of trial, at the time that the state filed its witness list before trial. Attorney Daly was also on notice that the state wanted to present this evidence in its rebuttal case during the state's case in chief, once the trial court denied the state's request to admit it in its case in chief. Finally, Attorney Daly was on notice that during the defense case in chief, that the state intended to present the prior bad acts in its rebuttal case and that the trial court was going to allow it in response to the affirmative defenses. Attorney Carlo testified that there was absolutely no strategic reason for why trial counsel would want the prior bad acts admitted. He testified that the prior bad acts drove a stake through the defense because the trial court instructed the jury twice that it could use the prior bad acts to undermine all of the defense witnesses, the affirmative defenses and the petitioner's credibility as to what he told Dr. Opsel and the petitioner's own credibility. This was a simple inadvertent discharge defense, which both Attorney Weiss and Attorney Carlo testified, and their testimony was unrefuted. But the habeas court failed to give any weight to their unrefuted testimony. Both attorneys testified that this evidence supported a simple conviction for manslaughter, and that counsel should have simply pursued an inadvertent discharge defense to obtain an acquittal on murder and ultimately obtain a conviction for one of the lesser included offenses of manslaughter. The petitioner, who has no prior history, criminal history, testified that the gun inadvertently discharged when the victim knocked it out of his hand and he fumbled to catch it. Notably, the petitioner's testimony was not refuted by any of the state's evidence. The victim was also only shot once, which our appellate courts have found does not necessarily indicate intent to kill. The petitioner and the victim were also strangers, and there was no evidence of a premeditated plan to kill the victim. There was also a very odd bullet trajectory here, indicating that the gun was fired in an awkward position, which was consistent with the petitioner's testimony that the victim knocked the gun out of his hand, it flew up over his shoulder, and he caught the gun and fumbled with it, and it inadvertently discharged. Ultimately, the gunshot wound on the far right side of the victim's back under the shoulder also reflects that the victim was not shot at point blank and was also consistent with the petitioner's testimony about the odd bullet trajectory and the inadvertent discharge. Contrary to the respondent's assertion, the petitioner's PTSD was not helpful to show why the petitioner drew his gun at the time of the shooting. In fact, it wasn't relevant why the petitioner drew his gun. It was only relevant that as to the petitioner's intent at the time that the gun discharged. Even if counsel did want to explain why the petitioner drew his gun to begin with, he didn't have to present the affirmative defenses. He simply could have presented the petitioner's testimony about his PTSD without presenting these affirmative defenses. Once the affirmative defenses were introduced, then counsel, during closing arguments, argued that the petitioner's PTSD resulted in him volitionally firing a gun due to the mental disease or defect. So he's simultaneously arguing an inadvertent discharge, which was completely undermined by his subsequent arguments about mental disease or defect. And contrary to the habeas court's conclusion and the respondent's assertion, counsel did concede during closing arguments that the petitioner fired a gun due to mental disease or defect. And the relevant pages, I would draw your honor's attention to August 22nd transcript, pages 1517 to 1518. And there was a quote, "And but for that incident in February of 1986, the weapon wouldn't have discharged and Peter Carone presumably would not be dead." And after that, counsel subsequently argued, quote, "But for mental disease and or defect, which made inoperative Adam ZACHS' control system, he is not guilty by virtue of that." So counsel is conceding, contrary to the habeas court's conclusion, that this was a volitional act of firing the gun, which was completely contradictory to the testimony of his own client. The reasonable professional responsibility dictates that an attorney review his client's statement and his testimony prior to the client testifying. And Mr. ZACHS had given a statement to the defense investigators 3 or 4 days after the shooting, specifically stating that the gun was inadvertently discharged and that he was aware and cognizant of that the whole time. So counsel should have used the petitioner's statement to develop solely an inadvertent discharge defense. Unless your honors have any questions at this time, I'd like to reserve the remainder of my time for rebuttal.
All right, that's fine. You'll have an extra 6.5 minutes in addition to the 5. All right, Attorney Oden, you may proceed.
Good afternoon, Your Honors. May it please the court. Again, for the record, I'm Samantha Oden, Deputy Assistant State's Attorney on behalf of the Commissioner of Correction in this matter. On the first issue, the habeas court properly concluded that Attorney Daly did not render deficient performance. The petitioner's entire claim is premised on several faulty assumptions, And so first, at the outset, it's important to note that Daly presented a theory of defense that used the PTSD evidence in two separate ways. Daly primarily used the PTSD evidence to show that the shooting was an accident and that the petitioner lacked the intent to kill the victim. The PTSD explained why he had a gun in the first place and why he withdrew the gun from his pants to be able to inadvertently shoot the victim. Daly also used the evidence alternatively as the basis for the affirmative defenses. Presenting the affirmative defenses did not concede intent to kill, and the jury's instructions at pages 36 and 37 make that clear. The court tells the jury that the affirmative defenses do not diminish in any way the state's burden to prove intent. And so by presenting these alternative defenses, Daly was simply maximizing the possibility of a favorable outcome for his client. The petitioner's claim also hinges on this assumption that the rebuttal evidence was devastating. And of course, some aspects of that testimony was harmful, but it certainly wasn't as damaging as the petitioner makes it seem. Daly could reasonably have decided that presenting these affirmative defenses and the evidence of the PTSD were worth the risks in opening the door to this uncharged misconduct evidence. And this is particularly true given that the rebuttal, the uncharged misconduct evidence actually supported the theory of defense presented because it was consistently showing that the petitioner did carry around this gun, did pull them out when he felt intimidated, and on those occasions did not shoot the gun. And Daly was also able to highlight that one of the state's own witnesses and the state's own experts diagnosed the petitioner with PTSD. And the petitioner consistently said to those experts that the gun accidentally discharged. The petitioner also tries to argue that Dr. Opsahl's report was conclusory, and therefore Daly shouldn't have presented this weak or unsupported defense. But we don't know from this record whether Daly talked to Dr. Opsahl outside of, met with him, talked to him on the phone about presenting this defense, especially when there's much more detailed information that was presented to the jury. And regarding the petitioner's claim that the only reasonable defense was to concede manslaughter, it's important to remember that Daly died prior to the habeas trial and the petitioner didn't testify. So we don't know a lot about the conversations between counsel and the petitioner, and this court has to presume competence. And so it's very possible that the petitioner adamantly did not want to concede guilt. And so even if Daly could concede guilt for the petitioner, it would certainly be reasonable for Daly to respect his client's choice and instead hold the state to its burden. And then just one last point that I wanted to make on this issue is that Daly could have considered the strength of the state's case and the very real likelihood that the jury would not believe that the shooting was an accident. This is particularly given the expert testimony from Trooper Gibbs about the amount of pressure that was necessary to pull the trigger on this gun, and his opinion over Daly's objection that the weapon cannot be made to fire accidentally. There was also evidence about the argument that occurred between the victim and the petitioner, and the evidence of the petitioner's consciousness of guilt in fleeing the scene, changing his clothes, and calling the bartender to make sure that no one knew he was at the bar. And so by presenting the insanity and EED defenses, instead of just advocating for manslaughter, Daly was simply providing another alternative for the jury to consider to find the petitioner not guilty of murder in the event that the jury did find the intent to kill. And I just wanted to briefly touch on the second issue regarding Daly's conflict of interest. The habeas court correctly concluded that this claim is procedurally defaulted. And so the true issue here really isn't whether Daly provided ineffective assistance based on this conflict, because unlike in Crespo, the trial court here actually addressed the conflict at trial and canvassed the petitioner. There was this procedure. So whether that waiver and whether that canvass was adequate is clearly a claim that could have been raised on direct appeal, as demonstrated in Navarro and Tilas, without additional factual findings. And so instead of bringing that claim on direct appeal 3 decades ago, when he should have, the petitioner chose to abscond. And if anything, this case exemplifies why we have the doctrine of procedural default. And I'd be happy to answer any other questions that your honors have on the remaining issues. Otherwise, I'll rest on my brief.
All right, seeing none. All right, Attorney Smith, you'll have 11.5 minutes.
Thank you, Your Honor. I would like to respond to several of the respondents' arguments. First, in response to the respondents' arguments that these were alternative defenses that were reasonably presented, that's simply not the case. While there are some cases where recognizing that inconsistent defenses can be raised, this simply was not the case here. Not in a case where one of the defenses is inconsistent with the testimony of the attorney's own client, and when the defense in itself is inherently weak, and also when this defense results in the admission of extremely harmful prior bad acts that decimated the defense. Contrary to the respondent's assertion, it was not counsel's strategy to admit these prior bad acts. In fact, counsel had repeatedly objected to the admission of this evidence, and also was able to successfully exclude them from the state's case in chief. So counsel ultimately has no choice but to try to incorporate them into his defense, but he was unable to do a very good job of doing that. The respondent makes much of the consciousness of guilt evidence. However, this evidence precisely shows that Mr. ZACHS was fully aware and was conscious, which refutes his mental disease or defect defense. Notably, Adam testified, although he did testify that there was a movie playing in his head for the initial portion of his encounter with the victim, when the victim had him up against the fence and was intimidating him, the petitioner subsequently testified that the movie stopped, and he testified that he came out of his dissociative state, saw the victim standing over him, and the petitioner had a gun in his hand. But he explicitly testified that after that, he was explicitly aware of what was going on, which means that he was aware of the gun accidentally discharging. And in his statement that he gave to counsel, he also indicated that this was an inadvertent discharge, and he consistently remained consistent with his position to all of the 3 psychiatrists, and again at trial. However, Attorney Daly manufactured this mental disease or defect defense in spite of his client's testimony, even though his client's testimony did not support it. And that was objectively unreasonable. He presents a defense that will cause a jury to discredit the testimony of his own client. And this court should find that no reasonably competent attorney would ever engage in such behavior. With respect to the conflict of interest claim, this claim was not procedurally defaulted. Our Supreme Court and our appellate court have found that these types of cases are exactly those that should have the testimony of the underlying attorneys on the case. And Attorney Daly had since died, but Attorney Weiss's testimony was extremely important because he ultimately testified that his reasons for not cross-examining the rebuttal witnesses were solely due to the fact that he was unprepared and not due to strategy. And so Attorney Weiss's testimony was very necessary to create this factual record for this claim. Unless your honors have any, I apologize, one moment, your honors. Counsel also, this claim also was not, the conflict of interest claim was not waived as well. The petitioner's apparent acquiescence during the canvass simply does not ameliorate the conflict of interest here. The record shows that his waiver just was not knowing, voluntary and intelligent. His waiver was premised on a cross-examination by Attorney Weiss actually occurring. And instead, Attorney Weiss remained silent and completely and left the testimony of these rebuttal witnesses completely unchallenged.
Attorney Smith, can you speak to this issue as to why the adequacy of the canvass with regard to the petitioner's waiver could not have been raised on direct appeal?
I think it was necessary to have Attorney Weiss testify about the circumstances behind the scenes, sort of what was happening there. and testify. I believe he also testified that the petitioner didn't know that he was going to ask, that he wasn't going to ask questions. I believe that's what the record states. So,
but I mean, but at the time of the direct appeal, he knew that no questions had been asked. So why, I'm struggling to understand why the waiver claim could not have been raised on direct appeal.
I think Attorney Weiss's testimony was necessary just to illustrate. Well, first the state argues procedural default with respect to the conflict of interest claim, and the state also argues waiver. So in both situations, Attorney Weiss's testimony was necessary for both of those. The waiver claim flows from the conflict of interest claim, and that requires Attorney Weiss's testimony. So they're all part and parcel the same issue.
All right.
Thank you, Your Honors. Unless Your Honors have any additional questions, I would rest on the arguments that I've made in my brief. And I thank Your Honors for your time.
All right. I don't see any additional questions from my colleagues. Thank you, counsel, for participating in this virtual format. We look forward to being back in the physical courtroom, hopefully next term. So thank you for your patience as we got through some technical issues. So the court will take the matter under advisement. We stand in recess until 3 p.m.